Asset division in a Texas divorce really refers to the process by which a court will decide who takes what assets, who takes what liabilities at the end of the day in your divorce decree. When dividing up assets in your Texas divorce, courts will follow the community property asset division scheme. And here's the thing, Texas is in a minority here, and we are a community property state. And here's the best way to think about what that means. I always explain this in terms of a number line. Y'all go back with me to elementary school. Okay, don't let me lose you here. It's not a huge math thing. But remember the integer line when you would learn about negative and positive numbers, and you would start out way over here at -10, go all the way up to 0, and then +10. Now, what I want you to think about is 0, that line of demarcation, is the date of the marriage. And then everything that happened after the date of marriage, like where the positive numbers would be on the number line, over here is presumed to be community property. And that means it's both of y'all's. If it was bought or acquired or earned during the marriage. But just because something was earned from your job, like money from your job, doesn't make it only yours. It means it's both of y'all's if it was acquired during the marriage. Same thing like if you own a house or a car and you bought it during the marriage with money you earned from your job during the marriage, that is most likely community property. In your Texas divorce, separate property might also come up in addition to community property. Now remember the number line example. After the date of marriage forward, things are presumed to be community property. And in fact, all property is presumed to be community. Here's the thing though, you can prove by clear and convincing evidence that property is separate. And the way you do that is you would show that you owned or had title to the asset or the property prior to marriage. Then it's a good chance that would be considered separate property in your divorce. Or if it was a gift or an inheritance during the marriage. And then rather than being both of y'all's like community, it would be each of y'all's for separate. So that would mean that what you brought into the marriage, so long as you protected it and handled it right, you should be able to take it back out of the marriage. Or if your grandma passed away and left you property and you kept it in your own bank account, then same thing, you should be able to take that back out of the marriage. Because Texas courts may not award separate property in a Texas divorce to someone else. So if you can prove by clear and convincing evidence that's your separate property, the court can't give it to the other person. In your Texas divorce, the court is ultimately trying to get to what it finds to be a just and right division of the estate. And you're like, what does that mean? And I mean, that's a pretty good question. And it probably means basically whatever that judge thinks it means, something like about 50-50. Now, that's if there's an absence of fault or some sort of reason why one party might get a disproportionate share, like more of the money and assets in the divorce. But ultimately, when people talk about a just and right division of the estate, there's this undercurrent of fairness, what seems right. And pretty much half and half of the community property will probably be within that bullseye, just depending on exactly what's at play in your case. If you and your spouse cannot agree on asset division in your Texas divorce, then you're going to find yourself in court. In any divorce or custody situation, things can happen in one of two ways. Number one, you can't agree. Number two, the court can order it. So if y'all can't agree, you've got to go to door number 2 and ask the court how it should be handled in absence of your agreement.